Ms. Tucker is the founder and executive director of the End of Life Liberty Project and served as lead counsel in 2 landmark U.S. Supreme Court cases, Washington v. Glucksberg and Vacco v. Quill, asserting that mentally competent, terminally ill patients have a constitutional right to choose aid in dying. Please join me in welcoming Ms. Tucker.
I'm so much shorter than Professor Pope. Thanks everyone for coming out and giving up your Saturday for this topic. I do believe the decision in Morris is a nadir. And so I'm sad to be here today. I'm sad we're not here celebrating that New Mexico robustly fulfilled the promise of the New Mexico Constitution. And I know others are as well. And I'll try to spend my remarks really sort of elucidating what I think those failures were. So in modern America, and I think Dr. Kate did a great job of helping us understand, the reality of modern medicine is sometimes it's really slow and brutal. This is a quote from Atul Gawande. Many of you may have read his books or his column in The New Yorker. He's the medical correspondent. And modern death can be really long. It can be brutal, and I've given you just a couple of examples that were pulled out of a recent amicus brief in a case I've been involved with in New York, where family member survivors told what the experience was for their family member who was dying a horrific death from ALS or cancer or AIDS. And I think one of the things that judges really do need to do, and I think Kate helped us do it this morning, is bring into focus the reality of what these patients are experiencing. So these deaths can be brutal, and they are the product of modern medicine. For all of its wonders, it has this very dark underside. So, why does it matter? Well, this is a quote from Ronald Dworkin. Many of you, since we're mostly lawyers here, know the wonderful career of Professor Dworkin, who's now gone on to his next lifetime. But he did write an amazing book called Life's Dominion, and that book, as well as an amicus brief he filed in the SCOTUS in the Quill and Glucksberg cases, really speaks to, with I think some poetic resonance, why this matters. So there are a lot of choices that patients make that change the trajectory to death. And Dr. Kate talked about them, Professor Pope talked about them. I'm just going to quickly touch on them. But patients around the country are empowered to invite medical behavior which precipitates death. And I use the word precipitate. I heard people struggling with, well, should we say hasten? These decisions to invite medical behavior that precipitate death include the patient directing the withdrawal of a ventilator and then suffocating to death, the patient directing the removal of a feeding tube and then starving and dehydrating to death, the patient refusing medication, and that might be dialysis, it might be chemotherapy, a patient directing the deactivation of a cardiac device. All of these behaviors invite medical conduct that precipitates the patient's death. And it is now standard of care that when those choices are made, the patient must and should and ought be kept comfortable, so there's active palliative care provided, and that's appropriate. We also now, and partly in the wake of the Glucksberg and Quill decisions, respect the right of very aggressive pain and symptom management. And so a patient has the right to receive as much pain medication as they need to get relief, even if it advances the time of death. And that was recognized in those SCOTUS decisions. And the failure to do that now is outside standard of care, and I have been involved in litigating those cases where we now do hold providers accountable for failing to treat pain adequately, and that's as it should be. I can't actually even see my slides from here, but is that palliative sedation? Voluntarily stopping eating and drinking. We empower dying patients, or patients who aren't even dying, to make the choice to refuse to stop taking food and fluid. And this will lead to death, of course, and patients should get good palliative support in that period. And that can be a long period. I mean, it depends on the condition and the size of the patient, how many days it will take to dehydrate to death. So that can be a long and lingering process. We do support the choice for palliative sedation. That was discussed in the Quill and Glucksberg decisions. Palliative sedation is an intervention for patients who have the kind of pain that's difficult or non-responsive to more conventional therapy. And here I'm a lawyer, and so Dr. Kate can shout out if I say something that offends a clinician. But this is for refractory pain and physical symptom. And the patient asks for this. Surrogate family members may be involved in that decision as well. And the clinician comes to the bedside and administers IV medication. So there's a very active role for the physician. And I know Professor Pope was talking about this ostensible division between passive and active. Well, that falls entirely into fiction when you think about palliative sedation, because the clinician starts an IV that induces total unconsciousness. And the medication is titrated so that the patient remains fully unconscious, so they have no awareness of their suffering. Food and fluid are withheld, so it is known with 100% certainty that death will arrive. Again, it may take several days or longer, depending on the condition of the patient. This is a choice that was respected by the SCOTUS and Quill and Glucksberg. You now see clinical practice guidelines from many different medical associations and professional societies. It's well accepted as in both law and medicine. And it's a choice that some patients may want to make, and for other patients they would recoil in horror and say, I don't want to lie there unconscious while people turn me and toilet me until death arrives and my family stands vigil. I don't want to die in that sort of sedated, unconscious way. So aid in dying is the choice of a mentally competent, terminally ill patient to request a prescription for medication that could be ingested to precipitate a peaceful death quickly. And that choice does run into the question of, do these ancient vague state statutes, which make a crime of assisting a suicide, does it run afoul of that? And so, yes, we have had some considerable litigation on this, and I'd like to trace back with you a bit about Quill and Glucksberg. I was counsel in putting those two cases together and litigating them through the federal courts. They were virtually identical, one on the West Coast, one on the East Coast. If law students are here, you appreciate that one of the reasons why the SCOTUS will take cases for review is if there's a split in the circuits, and our thinking was, why don't we have two similar cases in different circuits? We may create that split, and we wanted to get this in front of the SCOTUS. Interestingly, we ended up not having a split, but the court took both cases. Maybe it was a slow or boring day, but it's worth remembering what those claims were, and they both made both sets of claims. The liberty claim was to say that the SCOTUS has identified a sphere of intensely private personal decision-making about one's own body, medical treatment, life course. Those decisions are in a sphere that is protected from government usurpation. We don't let the government make those intensely private decisions. And so into that has fallen decisions around reproductive freedom, for example, choice of who one will have consensual sexual activity with, choice of who one will marry. These are the kinds of decisions that we reserve to the individual, recognizing the profoundly personal nature. That was the liberty claim / privacy autonomy claim. There also were equal protection claims made, and those were that because we allow so many types of medical behavior that precipitate death, to deny a patient who doesn't happen to be on a life-prolonging intervention an equivalent right is a denial of equal protection. So those were the claims. They went through the federal courts. At the time, and I think this is important to remember, this is the early mid-1990s. There was no open practice of aid in dying anywhere in the United States. And so the defendants, the state of New York and Washington and their various amici, were able to conjure a speculative parade of horribles. If this is permitted, these horrible things will necessarily ensue. This will be forced on minorities. This will be forced on vulnerable populations. People won't find out about or enroll in hospice, et cetera, et cetera. And at the time, I can tell you as a litigator, it was impossible to respond because there was no data. There was no information with which to combat that conjecture. Very, very difficult. So despite that, both the Ninth Circuit sitting en banc and the Second Circuit found federal constitutional protection. And I've given you long quotes. I'm not going to read them because I can't actually see it from here. But I invite you to read those words. The Ninth Circuit embraced the privacy liberty basis with very resonant language, finding that this, in fact, was the kind of choice protected under the 14th Amendment. And here, of course, another really beautiful passage. And I think this is the one speaking about courts standing as a bulwark. And I do want everyone to really remember that this is the function of courts. Both state high courts and the federal high court have this important, essential, critical role of standing as a bulwark to protect important privacy, liberty, autonomy matters. That didn't happen in Morris. This is the Second Circuit's language, which opted to find federal constitutional protection as a matter of equal protection, a different way to get to the same result. And this is some very powerful language about the fact that there really is no difference between these different choices, and let's acknowledge that. And again, I've given you a long quote, but I think it's critical to bring this into focus. There really is no difference. And I happen to like this, and I know that our opposing counsel in the Morris case will be speaking today as well, Scott Fuqua, and I think it's important to credit him and appreciate how he conducted himself as the Assistant Attorney General. He was very willing throughout the litigation to acknowledge that there really was no legitimate state interest when this is what we're talking about. So we had one in the Ninth Circuit, we had one in the Second Circuit. Both of the states petitioned for review. There was no split in the circuit, so it was in some ways a surprise and in other ways not, but there we were. The cases were set for hearing in tandem. And what happened, in my view, is the United States Supreme Court at that time, absent any data about an open practice and whether the speculative risks were real, was very concerned about that. And you cannot read all of the many decisions and opinions that were issued without understanding that. And in fact, Justice Souter says outright that for him, the substantiality of the factual dispute was determinative. The court was very careful to reserve the possibility that it might in future find a federal constitutional right. There was no definitive rejection of the claim. So Glucksberg and Quill do not need to be overruled for the SCOTUS to find federal constitutional protection. It was a provisional denial at that moment in time. So that's how I see it. And there was that careful reservation of possibly finding a future right. And of course, the interesting silver lining of the case was a very robust embrace of palliative sedation and the right of dying patients to receive aggressive pain and symptom management. And that was sort of an unforeseen benefit of the case. You don't always know what you'll get in litigation, and I will say that this was an unforeseen benefit. So what happened? Interesting timing. These decisions came out in the June of 1997. Oregon had passed by voter initiative the first so-called Death with Dignity statute, voter direct democracy. That was tied up for a few years in litigation that was resolved very soon after these SCOTUS decisions. opening the way for implementation. So the court's invocation of the laboratory of the states was almost immediately adopted by the state of Oregon, which served as the first laboratory. And Oregon's practice of open aid in dying has been happening now uninterruptedly, despite challenge, for some 20 years, and it has generated a rich body of data. The importance of that data, in my view, cannot be overstated because it answered all the questions that were the conjectures about risk, and the answer is there hasn't been risk. So that data, enormously important, and I do think it's been influential in the efforts in other states to move measures either through initiative or traditional legislative process through the legislature to enactment. And so I've given you the little list of states and how they got there, and I think that the data has been, for those swayed by data, and again, that's not everyone, but for those who are influenced by and care about data, it's been enormously influential. These statutory permissions do not mistake that they are enormously onerous and burdensome and restrictive. And I've given you just a few of the kind of provisions. These are the kind of incursions into a private, personal medical decision that we don't allow in any other context. No patient seeking palliative sedation runs this gauntlet. No physician administering palliative sedation has to do these behaviors. This is sort of a grotesque abomination of medicine, and it's aberrant. And so this is what's happening with these statutes. So the value of these statutory enactments, in my view, is that they have allowed the collection, they mandate the collection and reporting of data. That's a good thing in the sense that we have so much information now. We know who makes this choice, and we know why. Mostly they're patients dying of cancer. Many of them, a disproportionately high number are dying of ALS, which is a particularly brutal dying process. We know they're disproportionately highly educated, and we know they're nearly all enrolling in hospice and receiving comprehensive pain and symptom management. So we also know some things that I don't think any of us could have predicted, and it can be parsed out of the data. Many patients who run the gauntlet of the requirements to obtain their prescription don't go on to take it. It's so fascinating. They're comforted to have it. They've gone through a lot of process to get it. They put the medicine in the cupboard or the prescription in the nightstand, and that peace of mind was all they really needed, and they go on to die of their underlying disease. Something between 30 and 40% of the patients who get the medication make that choice. No one rushes to make the choice to precipitate death. The floor is raised for good end-of-life care for every patient in a state where aid in dying is available. We know that now because objective data tells us. Clinicians get busy taking more continuing education in pain and symptom management. They prescribe more strong pain medication. They make more referrals to hospice, and importantly, they make those referrals earlier. So, and doctor-patient communication improves because this can be candidly discussed. So the floor is raised for good end-of-life care for everyone, and then for the small fraction of patients who really feel this exercise of autonomy is important, they're empowered to make that choice. We have data about vulnerable populations. This has been exhaustively scrutinized by phalanxes of researchers parsing the data, and there has been no evidence of any disproportionate impact on vulnerable populations. Impact on families, and you have to credit researchers for coming up with such interesting studies. This came out of University of Washington and OHSU, taking a look at whether family members of a patient who chose aid in dying, like the case that Kate presented, Cody's case, looking at those families and trying to determine if there has been adverse impact on family member survivors, as is well known to impact survivors of suicide. And the findings have been exactly the opposite. These family members feel they honored their loved one, they supported their autonomy, they're more reconciled to the death, and their grieving is less complex. Really interesting study, and a stark contrast with what we see with suicide. So some are swayed by data, and fortunately, many of those are medical professionals. And so we're starting and have seen over the last decade the emergence of broad support from major national medical associations. Some of them I've listed for you. And again, I think that's important. Again, judges are people and want to know, is this dangerous? And having approval from major national public health associations and medical associations, I think gives some comfort that this, in fact, is not dangerous. So we have done some state court, and thank you, Professor Pope, for that whirlwind overview, to try to expand end-of-life liberty through litigation. Baxter versus Montana is a case I'm fond of. We did have an interesting success there. In Baxter, the lower court, and maybe I'm going to just ask, show of hands, how many of you have read the Montana State Constitution? Okay, different show of hands. How many of you know that one of the fascinating things about it has a dignity clause? It's the only state, I think Puerto Rico has one, but it's the only state to have that. So we had a privacy and dignity claim in the Baxter case, and we had a state statutory claim as well. And in the lower court, we had a very robust trial court ruling that yes, in fact, the Montana State Constitution does protect this enormously personal choice as a matter of intertwined privacy and dignity. So in some sense, we had mixed feelings about that ruling because how useful would it be outside the bounds of the borders of Montana if no other state had that? And in many ways, I was actually thrilled to see this state high court ruling that said we don't need to reach the Constitution. Constitutional avoidance. We don't need to reach that constitutional issue because we have ample statutory grounds, and we see the policy of the state of Montana is to empower patients with autonomy. This is that kind of a decision, and therefore there could be no criminal prosecution of a physician who respects the autonomy of a dying patient to choose a peaceful death through aid in dying. End of decision. Aid in dying in Montana is now governed not by statute. It is governed by the decision, which has some bright lines. The patient must be mentally competent and terminally ill, and the physician assistance is limited to writing a prescription. But there's no statute. So that long list of hoops and T's to cross and I's to dot, it's not in effect in Montana. So the practice is subject, as all medical practice is, to standard of care and best practices, which doctors like. That's how doctors practice medicine. And the beauty and the utility of that is practice can evolve. Best practices mean that when clinicians discover that it's more efficacious to do X, their peers will start doing X. So it's an evolving creature, and that's good for medicine. So that's the status in Montana. Here's Dr. Kate looking so fabulous in her white coat. And she was our fabulous plaintiff. And, you know, again, many law students here, when you're looking for plaintiffs, you want someone who can bring your case forward with the kind of grace and professionalism that Dr. Kate did. And she was an amazing plaintiff. So we did have this case that had both of these sorts of claims. I think this was the easy out for the court. It's not hard to understand that the choice of a dying patient for a peaceful death is no kind of suicide. That would have allowed the court to find for plaintiffs without going out on any constitutional limb. This is recognized by mental health professionals across the country. These are fundamentally and starkly different behaviors. It didn't happen. So we also had the state constitution arguments, and New Mexico, everyone here can be proud that it has a very protective constitution. This constitution affords greater protections than does the federal. And so we made the state constitutional arguments, and there has been, and my co-counsel in Morris, Laura Ives, who will be speaking later and who was fabulous in this case, it has a history and a tradition of protecting rights more broadly. And that's a beautiful thing. It didn't happen here. One of the things we did in Morris that we hadn't done in the other cases, and I'm glad we did it, is we took it to trial. We actually sat in the courtroom and had Dr. Morris testify and Asia Riggs testified, and we brought in experts from other states to talk about how it was working in Montana and in Oregon, and we put on our case, and the trial judge heard it all. And with that record, she made factual findings, and she found there was no harm to state interests, and that in fact this was a profoundly personal choice. And she issued her ruling, and a very powerful finding that there could be no right more fundamental than the right of a dying patient to be able to choose aid in dying. And that was a very resonant holding. The case went up on appeal. We had a three-way decision from the three judges on the intermediate panel, and you'll hear from some of those judges as well. And they kind of went three very different ways. And so it came to the New Mexico Supreme Court, and that court made huge mistakes. That court felt constrained by Glucksberg, and you can see these are excerpts of the opinion. The court failed in its duty to serve as a bulwark. It failed the citizens of Montana in failing to appreciate that Glucksberg presented no barrier to finding this right. So we had a record, an extensive factual record in Morris, and it was uncontroverted. There was no evidence that was on the other side. And the trial court's findings reflected that. And that evidence wasn't available in Glucksberg. So to suggest that it was following Glucksberg because of some of the concerns Glucksberg had about factual issues which have since been proven not to present when aid in dying is available makes no sense at all. We had, however, I will say, a ruling just a week or so ago in New York where the court made the same mistake. So, you know, sadly, I think the Morris court gave some basis for that next court to go that way, I think making similar mistakes. I think timid state courts, the kind of timidity that we saw in Morris is a serious abdication of judicial duty and privilege and power for exactly this reason. And I won't read that quote for you, but Justice Stevens had quite resonant language about that. And the SCOTUS, again, also talks about how this is a real disparagement of state constitutional rights. So what are they failing to recognize? I think there was a failure to recognize that Glucksberg clearly reserved the possibility that the SCOTUS would find federal constitutional protection under the less protective provisions of the federal Constitution. There was no recognition of that in the Morris opinion. The Glucksberg court urged that states experiment in their own ways. That could very well have happened. Here, it didn't happen. And that's unfortunate. And there have been major changes, and this, again, I think for the legal scholars in the room, this is perhaps the most concerning. There have been major changes in how federal jurisprudence is done since the Glucksberg and Quill decisions. So to suggest that there should be a rigid application of the Glucksberg jurisprudential process in 2016 or 17 is just wrong. And I mentioned, of course, the emergence of the data, and that the Morris court failed to observe or recognize or acknowledge. So what have we seen? Well, we've seen Lawrence versus Texas. Show of hands if you've read Lawrence and Obergefell. Yes, I hope most everyone has. So what has happened here? Well, in Lawrence, the SCOTUS said, we were wrong in Bowers versus Hardwick. 17 years, that's a short time for courts to do an about face, but the SCOTUS made a huge about face between Bowers versus Hardwick and Lawrence v. Texas, where it said it just got it wrong when it had said it was a crime to have consensual sexual conduct of a same-sex partner. Obergefell respected the right to choose a same-sex partner for marriage. And what both of those courts talked about that would again bear on this question is the SCOTUS said we must, when we do federal constitutional analysis, we must look to evolving societal support for a particular conduct. So because there was a groundswell of support for gay marriage, by the time Obergefell got there, the court said, we have to take note of that. Society has changed. And we take note of that in respecting this as a privacy and liberty issue. Same is true for aid in dying. In society, there's a huge groundswell of support. Any public data would show about polling 70 plus, maybe it's now 75% of Americans across every demographic support this choice. And yet to fail to acknowledge that and do a rigid historical analysis is just wrong, even if you look to the SCOTUS. And so, yes, again, here's a little snippet out of the Obergefell opinion and a snippet out of Lawrence. And so Glucksberg's jurisprudential approach had essentially been abandoned by the SCOTUS by the time the Morris Court got the case, and yet it points to Glucksberg. And on top of that is the failure to acknowledge that it was the substantiality of the factual dispute that caused the Glucksberg court to hold off, and now we have data. So it was a multiple compounded error, which makes it such an embarrassment. And I don't have the slides, but I did today, and I want to close with this. I did today spend a little moment looking back at the history of former SCOTUS Justice Lewis Powell, who himself acknowledged at a gathering like this to law students in the wake of Bowers. After he had retired, he essentially recognized that it was a big mistake. And he was the vote that swung Bowers for 5 votes to criminalize consensual adult choice of sexual partner. And he said it was wrong. And you might say to yourself, well, so what utility is there in a Supreme Court justice acknowledging that they've made a bad and erroneous decision? And I think Larry Tribe has said it very well, and it undermines the moral authority to the extent there is any in that opinion. And so I think it can be important to future courts when state high court or federal high court judges acknowledge they've made error. And I hope that will happen here. So thank you so much. And